Good morning, everyone. Welcome here to Assembly Judiciary. Welcome, everyone, here in Carson City. As I see, we have a group visitation day today. Welcome to those watching in Las Vegas. And of course, anyone watching online through Nellis or our YouTube legislative station. With that, Committee Secretary, please take the roll.
Assembly members Cole.
Here.
Dahlia.
Here.
Gonzalez.
Here.
Gray. Hanson.
Here.
Hardy. LaRue Hatch.
Here.
Marzola.
Present.
Moore.
Here.
Nadeem.
Present.
Orton-Licker.
Here.
Roth.
Here.
Urick. Chair Miller.
Here. And with that, please mark members Gray and Urick present when they arrive. With that, just a few reminders for today. The agenda is posted on Nellis, and on that agenda, you will be able to find the phone number and the meeting ID for anyone wishing to participate over the telephone. The phone number today is 888-475-4499, and the meeting ID is 816-031-36097, and that's for anyone wishing to call in and testify or to make public comment at the end of the meeting. We ask that those presenting bills keep their presentations to 15 minutes, and that anyone testifying on a bill or making public comment later keep those comments to 2 minutes. Of course, anyone speaking, please make sure that you state your name, and the first time you state your name, that you spell it so that we have it correct for the record. Of course, another reminder to please make sure you turn down the volumes on all of your electronic devices. Today, we will have a bill presentation and work session at the end of today's meeting. So with that, I will open up the hearing on Assembly Bill 467. It revises provisions relating to forensic mental health. Members, there was an amendment that was sent to us last night, so please make sure you check your emails, and if not, there were physical copies that were provided here in the room. And with that, we'll give the Assembly member a few minutes to get settled in, and whenever you are ready, please proceed.
Good morning, Chair Miller, Vice Chair Marzola, and fellow members of the Assembly Judiciary Committee. My name is Erica Roth, and I'm proud to represent Assembly District 24 in Washoe County. Thank you, Chair, for the opportunity to present Assembly Bill 467 this morning, which aims to increase access to forensic mental health care. With me today to present the bill is Jennifer Rains, Chief Deputy Washoe County Public Defender, who oversees their Competency and Behavioral Health Division. However, this has truly been a multi-agency, multidisciplinary effort. In the audience, available for questions as subject matter experts include Judge Walker, who oversees the Competency Court at the 2nd Judicial District Court, the Department of Public and Behavioral Health, the Washoe County Sheriff's Office, which is currently implementing a successful mental health unit within their jail, the district attorneys, and Jonathan Norman with the Nevada Coalition of Legal Service Providers. As members of this committee may be aware, forensic mental health plays a crucial role at the intersection of mental health and our legal system. It encompasses the assessment, treatment, I believe Bridget Duffy is also in Vegas for the juvenile portion of that. It encompasses the assessment, treatment, and understanding of individuals with mental health issues who become involved in legal proceedings and are deemed not constitutionally competent to stand trial. As a result, the individual is required to be treated to competency at a qualifying forensic hospital in this state. To illustrate, a common scenario we see in our competency courts include an individual who's experiencing a mental health crisis who may be arrested in downtown Reno or on the Strip for property damage. The individual meets with their attorney, and it's determined that they likely do not meet the legal threshold to be prosecuted based on their inability to understand the proceedings against them or assist in their defense. Competency proceedings are then initiated, where the individual is evaluated for competency, and when found not competent, they must be transferred to a state-run forensic psychiatric hospital within 7 days. However, Nevada has faced significant challenges in meeting the demand for forensic evaluation and treatment services. Our forensic psychiatric hospitals have struggled to keep up with evaluating and treating patients in the criminal justice system for decades due to limited bed capacity, increased long-term commitments, and staff shortages. This has resulted in wait lists and delays of up to 1 year in admitting individuals from jails. In many instances, once defendants were eventually treated and returned to be prosecuted, they had run their entire sentence and would be released right back onto the street with no support, just to find themselves back in jail facing competency proceedings when their meds wore off. These issues resulted in the state being sued for the first time in 2005 for failure to timely transport defendants within the statutory requirement. Following litigation, the state entered into its first consent decree, agreeing to transport defendants within 7 days. In 2013, the state was again sued for failure to transport defendants within the statutorily required time, and again entered into a consent decree with the same terms. That consent decree ended in 2020, and we are once again on the precipice of serious legal action. While we have not reached the level of a consent decree, the state of Nevada is still facing serious consequences for our failure to timely transport individuals. In 2022, district courts began imposing a $500 fine per inmate per day waiting per individual waiting to be transported to be paid to a nonprofit organization. In 2023, when the Supreme Court upheld the fines, Clark County had an average wait time of 123 days. To date, the state has incurred almost $200,000 in fines. Not only does this have devastating financial consequences, we cannot forget the human beings who are suffering from severe mental health issues who languished in county jails, waiting to be properly treated before they could move forward with a case. And it is with all of this that I sit here today with such a diverse but equally dedicated group of stakeholders who have made great strides in the last year to tackle this issue within the statutory confines currently in place. Assembly Bill 467 seeks to address several critical challenges in this area and improve our state's ability to care for these individuals. The proposed changes in this bill are designed to address the growing demand for forensic mental health services in our state. By providing more options for treatment, we aim to reduce wait times, improve access to care, and ensure that individuals receive appropriate treatment in a timely manner. With the chair's permission, I will now turn to my co-presenter, Jennifer Rains, to discuss the steps taken in the last few years through our mental health units in the jails and implementation of competency courts in our 2 largest counties, and to identify where gaps still exist.
Good morning. Jennifer Rains, Jennnifer Rains. Thank you, Chair Miller and members of the Judiciary Committee. Assemblymember Roth highlighted the crisis in forensic mental health, which is not unique to Nevada. Washoe County leaders have been working closely together to respond to the crisis and improve the system guided by the sequential intercept model, or the SIM, which helps communities understand how people with behavioral health disorders become involved in the criminal legal system. It also identifies ways to connect these individuals with treatment instead of jail whenever possible. The SIM outlines 6 points where intervention can happen, and Assembly Bill 467 focuses on Intercept 3, the courts and the jail. Guided by the SIM, experts across the country have been working to improve how the legal system handles mental health cases. The National Judicial Task Force to examine states' courts' response to mental illness released key recommendations in 2022. One recommendation was for courts to create competency dockets that facilitate access to appropriate diversion from forensic hospitals and outpatient restoration resources for cases involving competency. To see these ideas in action, Washoe County stakeholders visited Miami-Dade County, Florida, in partnership with the National Center for State Courts, to learn about what has become known as the Miami Model, a project held out as the national model for innovative strategies to respond to behavioral health issues in the criminal legal system. Stakeholders returned inspired and motivated. From these visits, Washoe County developed a competency court under the leadership of Judge Walker. The first docket was heard in September 2023. Since then, the court has grown to review upwards of 30 cases each week. The court uses a multidisciplinary team approach to allocating limited forensic restoration beds to individuals charged with the most serious offenses, while connecting others with services focused on treating their behavioral health symptoms and reintegrating them into the community, rather than simply restoring them for purposes of prosecution. A key takeaway from the work in competency court thus far is discretion. And for purposes of today's discussion, discretion among the DPBH providers to make placement decisions based on the needs of the individual, risk to the community, and other clinical factors. Right now, after evaluators have opined that someone is not legally competent to proceed, the court orders that the person undergo restoration with the administrator of DPBH. DPBH has only two options: inpatient secure forensic hospitals, that will be Lakes Crossing or Stein, or outpatient treatment programs. There remains a lengthy waiting list for admission to Lakes Crossing, leaving people in the county jails to languish. A topic for another day, outpatient restoration depends on someone having adequate resources and support in the community. AB 467 would provide an additional option for restoration by permitting DPBH facilities within a jail to provide restoration services. Last fall, roughly a year after competency court started, the Washoe County Sheriff launched a jail-based mental health program in partnership with DPBH. This program provides early mental health treatment for individuals in jail whose competency is in question. Again, this is treatment only. That does not encompass the legal education portion of restoration. However, seeing this program in action has shown those of us who were deeply skeptical about treatment in a correctional setting a model of what's possible to better serve individuals. The special unit resembles a forensic inpatient setting. The specially selected custody staff act more like forensic mental health technicians than traditional housing deputies. The clinical services provided are like those provided in a forensic setting, including groups, prosocial activities, and psychiatric care. The key difference now between the jail unit and Lakes Crossing is the legal education and the opportunity for restoration evaluations. There are individuals in that unit who have achieved psychiatric stability and could complete the legal education component now. However, they continue to be held at the jail while they wait for their bed at Lakes Crossing. For these individuals, doubt as to their competency could be resolved, allowing them to proceed through the adjudication process. This would make the most difference for individuals charged with gross misdemeanors or low felonies. Currently, admission to Lakes is based on when they were ordered to go there. So someone charged with a gross misdemeanor is on the same admission list as someone who is charged with a Category A felony. The current waiting time for transport is approximately 3 months for individuals in Washoe County who have already been ordered and are around number 20 on the list. This means someone charged with a gross misdemeanor could serve the maximum allowable sentence while pending competency restoration. Why is Assembly Bill 467 important? AB 467 would give DPBH more flexibility to assign individuals to treatment settings that meet their specific needs. Even if just 1 or 2 people receive treatment in a facility other than Lakes Crossing, it would reduce waiting times for others who need specialized forensic inpatient beds. This allows the state to continue to improve how it handles mental health cases in the legal system, helping individuals get the care they need while ensuring public safety.
Thank you. And with the chair's permission, I'll just briefly walk through each section of the bill. I'm sorry, Erica Roth for the record. So looking at the amendment, Section 2 of the bill is being removed. Just a little background on that is Section 2 was initially requested to kind of lay out what is already happening in practice. We have in both Washoe and Clark counties, really extensive and well-working competency courts where the district attorney, the public defenders, and each judge sit down together to determine the best course of action for each individual based on the alleged offense and their treatment needs. But there were some collateral consequences with that language, and so based on that, we decided to remove that portion of the bill and really focus on what's most important, which is ensuring that DPBH has the tools that they need to appropriately place each individual. So moving to Section 3 of the bill, Section 3 seeks to expand the availability of facilities for treatment to competency. The amendment, as you can see, is permissive language. It would allow the Division of Public and Behavioral Health to enter into a contract with the sheriff's office within the county jails to provide some of this treatment. That is permissive language. I was approached just this morning about potential soft opposition. I did request language that would be amenable to all parties at the beginning of session. So I'm a little disappointed this morning, but we are working with all stakeholders to find language that works for everybody. The intent of the bill is that it is permissive. It doesn't take the duty away from the state. The state still has oversight and administrative oversight over these programs. It just allows one more option for individuals to actually be treated when we have them in these very successful mental health units in the jail. And then lastly, Section 20 addresses competency for juveniles. I know Bridget Duffy is present in Clark County to answer any questions on this. Juvenile law remains very elusive to anyone who does not practice it, but the crux of the issue with Section 20 of the bill is that we have individuals who are juveniles who are found not competent, but we can't place them anywhere. We just don't have the appropriate facilities in this state to place all of them. And so this allows some judicial review when we are unable to place those individuals and they are just languishing in jails to find some more appropriate placement for them and some other treatment programs for them that can help them address their mental health issues. And with that, I believe we are ready for questions.
Thank you so much for your presentation. I'll give members a few moments to formulate any question request. And our first question will be from Assemblymember Cole.
Good morning. Thank you for this legislation. I think this is a very, very, very important issue, both on the adult and the juvenile side, so I appreciate you bringing this. My question is when it comes to the private facilities, understanding that various aspects of mental health require some security, right? So sometimes there needs to be a locked ward and whatnot. And I think you mentioned that this is the most important for the gross misdemeanors and the low-level felonies, but are we going to ensure that the appropriate facilities have the appropriate security based on the crime, if that makes sense?
Erica Roth, for the record, Chair, through you to Assemblymember Cole.
Please go direct.
Thank you so much. Thank you for the question, Assemblymember Cole. I'll take a stab at this, but then probably pass this off to my co-presenter since she's the subject matter expert. What we're focused on here, and these issues are very complicated. So what we are focused on is forensic psychiatric care, which requires in most instances that the defendant be sent to a secure and locked facility. And that gets at the crux of the issue that we face in the state. We have two forensic hospitals in this state, one down south and one up north. And for all purposes, if you ever have the opportunity to visit, they are very much like a jail. They're secured and locked. And that is why, with these mental health units in the jail, it allows us to provide additional bed space in a very similar setting. But I will pass to my co-presenter in regards to any civil bed treatments that are happening with the diversion.
Jennifer Rains for the record through Madam Chair. There may be some confusion, and that's where the amendment that I believe you just received last night could help clarify. The reference to private facilities was part of the 433A idea for change that is no longer being put forward because it can be confusing and there's some additional work to be done. The clear intent of this legislation would be to give the administrator of DPBH an additional tool in that proverbial toolbox, but the administrator would still be responsible for assigning based on risk, need, clinical indication. So there would be oversight in terms of placement by the division.
Thank you. Our next question will be from Assemblymember LaRue Hatch.
Thank you, Chair. Thank you for bringing this important bill this morning. So we hear often in this committee about the overcrowded conditions in our jails, about the overburdening of the court system. I wondered if you could just speak to how this may help alleviate some of those issues.
Thank you so much for that, Erica Roth for the record. Thank you so much for that question, Assemblymember LaRue Hatch. I'm actually going to phone a friend on this one. If we could have Judge Walker possibly approach the table. I think that he's, he sits from a bird's eye view of this issue, and I think he can really give a holistic answer.
Good morning, Madam Chair. Egan Walker. I have the privilege of serving as a district judge in Washoe County, and I am the competency court judge. If I may answer the question through you to Assemblymember LaRue
Yes,
Hatch.
please go direct.
Thank you. So, Assemblymember, the way this will help is multifold. First, it will reduce the time people wait to go to lakes, because frequently what happens when people get to lakes is they need to transition onto medication. They need to begin treatment. So it will reduce the time it takes to get to lakes. It will reduce the stay at lakes, because if they have already transitioned to medication, already begun in a therapeutic milieu, that work can be built upon at lakes. And when people get out of lakes and return to the jail, after presumably being returned to competency, they will succeed better. And so it helps across the range. And I might just mention, this idea is not new. So that 2013 consent decree had a legislative investigative report out of this body, meaning the legislature, that recommended jail-based treatment.
Thank you so much. Our next question is from Assemblymember Hanson.
Thank you, Chair, and thank you so much for being here and presenting this. Having brought a juvenile mental health bill a few sessions ago, I can understand how there's a lot of layers and appreciate your sensitivity and to the stakeholders as well. I would just wanted to know, if I'm looking at the amendment, it's section 20, the part that deals with children. Can you just explain? I think it'd be nice just to have an explanation for those that might not be as familiar about why those changes in section 2 of section 20. I'm
Absolutely.
sorry, sub 2 in section 20.
Erica
Thank you.
Roth for the record. Thank you so much for that question, Assemblymember Hanson. I'm going to phone a friend down to Las Vegas if Bridget Duffy is available.
Good morning, Chair and members of the Assembly Judiciary. I'm Bridget Duffy, B-R-I-G-I-D, D-U-F-F-Y, Assistant District Attorney in the Juvenile Division for the Clark County District Attorney's Office. And thank you for that question, Assemblymember Hanson. Section 20 is important because while we made advances in 2021 toward juvenile competency and requirements of who's in charge of making sure that these children get treatment, that statutory change in 2021 didn't really go far enough, because in juvenile court, we're having the exact same issues as they're having with adults. Children are sitting in juvenile detention for months. Most recently, 4 months from the time the court ordered a child who was deemed incompetent to be placed into a state treatment facility, sat for 4 months without treatment in a juvenile jail before transport was actually made. And that's just one example. We have many others, and the average wait time is around 120 days for children waiting for state placements for mental health treatment. So the amendments to Section 20 will get us closer to what we do and how we treat adults, which is important because we've been talking about adults and competency, as you heard from Assemblymember Roth, for years, consent decree after consent decree, outrage in articles that we're seeing. But we're not really getting that same attention on our juveniles, which we should because they're as important, if not more important, with all due respect, to adults. So this actually will allow it to be that the administrator shall immediately accept placement. And if they do not have a treatment facility that's appropriate, then they will need to provide whatever treatment that they have available while they find the appropriate treatment facility. And I believe that takes us steps further from our 2021 amendment to 433B 320 to getting these kids appropriately placed quickly.
Thank you. Erica Roth for the record. And I'll just briefly add on that. When we're talking about what's happening when these individuals, whether they're adults or they're juveniles, waiting to be treated, before we had the mental health unit stood up in both the Washoe and Clark County jails, these folks were just languishing. They weren't getting any treatment, and these programs have really been able to turn that around. But this brings it one step closer to really giving this holistic Miami model approach to the state of Nevada. But as far as the juveniles go, 4 months for an adult is unconscionable, but 4 months for a child, that is such a significant portion of their life that they are waiting to find some sort of treatment. And so, I'm really proud that we are addressing this for the juveniles as well, because it is a serious issue. And, it is just such a significant time in their life where they are separated from their family. They don't have the support that they need. So.
Thank you so much for that. And we do appreciate that with the juveniles, they do require additional services, including educational support and, all the other things you mentioned, but our chances at rehabilitation are also greater at a younger age. So we do appreciate that. Thank you. With that, I don't see any additional questions from members at this time, so I will go ahead and open it up for testimony. Again, just want to remind everyone to please keep your testimony to 2 minutes each. Please make sure that you state your name and spell it for the record. And we will begin here in Carson City with testimony in support of Assembly Bill 467.
Good morning, Chair Miller and members of the Assembly Judiciary. Paloma Guerrero, P-A-L-O-M-A-G-U-E-R-E-R-O, on behalf of the Clark County Public Defender's Office. The Clark County Detention Center is the largest mental health provider in the entire state. Over 1/3 of the people at CCDC are on some form of psychotropic medication. We have a severe mental health crisis in the state. And these long competency wait times are not just in Washoe, they're happening in Clark, which led to the death of one of our clients. Our client was found incompetent and while waiting to be transported was murdered by his cellmate. That death should not have happened, and this bill is going to make sure that it doesn't happen. This bill is going to save lives and make sure that people get the treatment that they need. Thank you.
Good morning, Chair Miller, members of the committee. Jason Walker, Jason Walker, representing the Washoe County Sheriff's Office, supporting Assembly Bill 467 with the amendment. Our jail-based mental health unit is a supportive assistant to our mental health individuals in custody. The Washoe County Sheriff's Office has established and implemented this forward-thinking approach to dealing with some of our mental health in custody individuals that get stuck in custody over a long period of time. We see a significant need for this program as it decreases time spent in custody and gets individuals the programs, attention, and medication that they need. With the implementation of our jail-based mental health unit, we've been able to reduce transfer wait times from 6 months to 4 months on average, urging your support to push this legislation forward as I see our program as a potential model for other detention facilities, as well as good building blocks for where a jail-based mental health unit will progress in the future. Thank you.
Good morning, Chair Miller, members of the committee. For the record, my name is Cadence Matievich, Cadencematijevich, and I'm the Government Affairs Liaison for Washoe County. Washoe County is focused on increasing access to behavioral health resources in our community. We are grateful that the state of Nevada has been a partner with us in these efforts, and you just heard from Lieutenant Walker the successes that Washoe County is having with our jail-based mental health unit. We are grateful to Assemblymember Roth for bringing this bill forward. We think it will build upon those successes, and you've heard many of the ways that these programs are currently bringing resources not just to people, but also helping to improve the times that it's taking to get to our facilities. And when people return from the competency, they return to a program that continues to support them so they remain competent. And we really believe that this pays dividends across our community, and we urge your support. Thank you.
Chair Miller, members of the committee, Jonathan Norman, NORMAN, Nevada Coalition of Legal Service Providers. We represent the vast majority of the foster kids in the state of Nevada, and many of those kids also have juvenile justice charges, and the languishing that Ms. Duffy talked about is something we see on almost all of those cases. And when I think about Section 20, I think, if the most inappropriate placement is JJ, and we can just move slightly up, closer to the most appropriate placement. We may not get there, but that's better than them in JJ. So when I think about what Section 20 does, is it moves the kid into a more appropriate placement on their way to the most appropriate placement. So thank you for your consideration.
Thank you. Mr. Norman, can you define JJ for everyone in the room?
Juvenile justice, so detention.
Chair Miller, Egan Walker again for the record. I have the privilege again of serving in Washoe County, and I would offer that I am a former chair of the Juvenile Justice Oversight Commission here in Nevada. And so in a holistic sense, I would offer to the Assembly members as a whole this comment. What this is smart on justice. It's not just a requirement for justice, but it's smart on justice. What it means is that rather than people languishing in jail, either children or adults, often without treatment, often without medication, and getting worse, we address people's needs where they're at the time they need those needs addressed. And for me as a judge, the end goal is a healthier, safer community, right? I want people, if they are captured by the criminal justice system, appropriately, hopefully, to leave the criminal justice system in a way so that they don't commit the next crime. And the difficulty with people languishing in jail unnecessarily for months on end is we make them worse. As I described to my prosecution colleagues, many times we guarantee the next victim by making them worse in the process. And so I strongly urge you to support this legislation. It is a step in the right direction toward the right treatment for the right people at the right time. Thank you.
Thank you. Is there anyone else here in Carson City? Not seeing anyone. Is there anyone there in Las Vegas that would like to testify in support of Assembly Bill 467? Not seeing anyone. Broadcasting, would you open the lines?
If you would like to testify in support of Assembly Bill 467, please press *9 now to take your place in the queue. Again, if you would like to testify in support of Assembly Bill 467, please press *9 now. Caller with the last three digits, 542. You are unmuted and may begin.
Good morning, Chair Miller and members of the committee. This is Jeff Rogan, Jeff Rogan from Clark County. With the conceptual amendment and the Assemblywoman's commitment to work through any language in Section 3 that's in dispute, Clark County is in support of AB 467. Jail-based competency is a great idea, as evidenced by the efforts of Washoe County over the past year. Many offenders who have been found incompetent by the court spend considerable time in jail waiting for a bed to open up in a treatment facility. During this time, their criminal matter is stayed, meaning a defendant is housed in their jail without receiving any treatment and without any progress being made toward a resolution or trial of the criminal matter. If a program is feasible in a county jail or detention facility, as Judge Walker said, a jail-based system has the potential to eliminate these waiting times and restore a person to competency much more much more quickly. I want to thank Assemblywoman Roth and Ms. Raines for working on this bill. The Assemblywoman brought all stakeholders into this conversation early on before session to ensure we all had an opportunity to participate, and we promise to continue to work with her as this bill moves forward. We urge your support. Thank you.
Thank you so much. Next caller.
Chair, there are no other callers choosing to testify in support at this time.
Thank you. Then I will go ahead and open it up for opposition testimony here in Carson City.
Good morning, Chair Miller, Vice Chair Marzola, and members of the committee. Jennifer Noble, Jennifer Noble, on behalf of the Nevada District Attorneys Association, here pursuant to rules of the committee. I'd like to thank Assemblymember Roth and actually Judge Walker for thoughtful conversations and for including stakeholders in the idea from this bill from the beginning. We certainly have an issue with folks being delayed in their admission to competency restoration and mental health care, and so we support wholeheartedly the idea behind this bill. Unfortunately, this is an intersection, it's a complex intersection between civil and criminal law. And the question of whether or not somebody is competent to stand trial is a bit different than whether or not they are a danger to themselves or others. Because of the extensive litigation that's gone on, we just need a little bit more time. I did try to contact folks over the weekend, membership, and go over the conceptual amendment that became available this morning. Unfortunately, they're still working through some concerns that they have. I'm trying to get more precise details about those concerns so that on the other side we can be in support of this legislation. And we do, again, thank the Assembly member for bringing it.
Thank you so much. Is there anyone else here in Carson City wishing to testify in opposition? Okay, then I'm going to move to Las Vegas, and it's my understanding that I will first start with opposition testimony in Las Vegas, but it's also my understanding that there was someone who wished to testify in support, so I'll take opposition first and then move to support. So is there anyone there wishing to testify in opposition? Not seeing anyone. Is there anyone wishing to testify in support of Assembly Bill 467? And I'm so sorry, officer, I must have just assumed that you were there working and not there testifying, but please proceed. We do have our legislative police there as well in that building, so I apologize. Officer, please proceed.
Thank you. Thank you, Madam Chair and members of the Assembly. My name is Nita Schmidt. I'm I'm the Deputy Chief of Detention Services Division over the Clark County Detention Center for the Las Vegas Metropolitan Police Department. And for the sake of brevity, I just wanted to give our support based on the comments from Mr. Rogan from Clark County. We also run a program at our facility, and we also wanted to lend our continuing support of that program as well as changes to this statute. Thank you.
Thank you so much. And again, I do not believe there's anyone there to make opposition testimony in Las Vegas. So I will move to the phones. Broadcasting, will you please open the lines?
If you would like to testify in opposition to Assembly Bill 467, please press star 9 now to take your place in the queue. Again, if you would like to testify in opposition to Assembly Bill 467, please press star 9 now. Chair, there are no callers choosing to testify in opposition at this time.
Thank you so much. Then I will open it up for neutral testimony, beginning here in Carson City. Anyone wishing to testify in neutral? Not seeing anyone? Is there anyone in Las Vegas that would like to testify in neutral? Also not seeing. Is someone coming? I guess not. Okay, they're all looking. So, not seeing anyone approach, then I will go ahead and open the lines. Broadcasting, please open the lines.
If you would like to testify in neutral for Assembly Bill 467, please press star 9 now to take your place in the queue. Caller with the last three digits, 234, please press star 6 to unmute your phone. You may begin.
Hi, good morning. This is Marla McDade Williams, M-A-R-L-A-M-C capital D-A-D-E-W-I-L-L-I-A-M-S. I serve as the administrator for the Division of Child and Family Services. I just wanted to go on record that when a youth who is needing treatment to competency is ordered to the Division of Child and Family Services, we do work on finding placements for their treatment. However, the need for secure placement is a barrier with these youth. Desert Willow Treatment Center is a secure facility, but we don't have forensic level staff to ensure the safety of other patients in the facility. We do our best and private facilities do their best, but the failure rate for treatment in private facilities is high because of the intense needs and safety issues associated with these youth. Thank you.
Thank you so much. Next caller.
Chair, there are no other callers wishing to testify in neutral at this time.
Okay, thank you. Then I will close testimony and offer our bill sponsor any final remarks. Thank you so much. She's choosing not to make any final remarks. So with that, I will go ahead and close the hearing on Assembly Bill 467. Members, next on our agenda, we have a few more items. We have bill introductions as well as our work session. So we will go ahead and move to our bill introduction. We have two bills to introduce today. First one will be BDR 52867. And again, with the BDR introduction, just reminding folks that this is not, that your vote for today does not insinuate your support for the measure. It's actually just voting to turn the BDR into a bill on the floor. And so with that, BDR 52867 establishes certain deceptive trade practices relating to the sale of or an offer of sale for certain hemp products. With that, members, are there any questions? Not seeing any, I will entertain a motion. So moved. I have a motion by Vice Chair Marzola and a second from Assembly Member Gonzalez. Any additional comments or questions? All those in favor? Aye. Anyone opposed? And the motion passes. Our next BDR for today is BDR 31144, and it revises provisions relating to constructional defects. Members, are there any questions? Not seeing any. I will entertain a motion. I have a motion from Vice Chair Marzola. Is there a second? I have a second from Assembly Member Gonzalez. Any additional questions or comments? Not seeing any. All those in favor? Aye. Anyone opposed? Thank you. And the motion carries. We will now move on to our work session. We have 4 bills that we will work session today, starting with Assembly Bill 25, and I will turn it over to our policy analyst.
Thank you, Chair Miller. For the record, Cesar Magarejo, Committee Policy Analyst. I will note that as nonpartisan staff, I can neither support nor oppose any of the measures that come before this committee. As the Chair mentioned, first bill is Assembly Bill 25, which revises provisions relating to offenders, as sponsored by this committee on behalf of the Department of Corrections and was heard on March 11, 2025. There is an amendment proposed by Chair Miller, which revises Section 1 by including specific criteria for providing annual pelvic examinations and mammography to female offenders based on various factors, and removes the requirement for the department to adhere to community standards and national guidelines when providing medical and behavioral health care services. And Madam Chair, that's all the amendments.
Members, are there any questions? Not seeing any, I will entertain a motion.
Motion to amend and do pass.
I have a motion to amend and do pass from Vice Chair Marzola. Do I have a second? I have a second from Assembly Member Gonzalez. Is there any further discussion on the motion? Not seeing any. All those in favor, please say aye. Aye. Anyone opposed? And the motion passes unanimously. I will go ahead and assign that floor statement to Assembly Member Moore. Next on our agenda is Assembly Bill 97.
Thank you, Chair Miller. Assembly Bill 97 revises provisions relating to public safety. Specifically, the bill requires each agency of criminal justice and other agency dealing with crime to submit the information required to the Central Repository for Nevada Records of Criminal History of Department of Public Safety by using the National Incident-Based Reporting System, and there are no amendments for this measure.
Thank you. Members, any questions? Not seeing any, I will entertain a motion to do pass. I have a motion from Vice Chair Marzola. Do I have a second? I have a second from Assembly Member Nadeem. Sorry, Gonzalez. Members, any additional questions or comments? Not seeing any. All those in favor, please say aye. Aye. Anyone opposed? And the motion passes unanimously. I will assign that floor statement to Assembly Member Nadeem. Next, we have Assembly Bill 107.
Thank you, Chair Miller. Assembly Bill 107 revises provisions relating to foster care, sponsored by Assemblymember Brown May, and was heard on February 27, 2025. There is an amendment that was submitted by the Clark County. The amendment to AB 107 removes the exemption for decriminalized offenses, shortens the look-back period for marijuana possession offenses from 7 to 5 years, and adds Assembly Members Gonzalez and Gray as co-sponsors of the bill. And Madam Chair, that's all the amendments.
Members, any additional questions or comments? Not seeing any, I will entertain a motion to amend and do pass.
Motion to amend and do pass.
I have a motion from Vice Chair Marzola. Is there a second?
Second.
I have a second from Assembly Member Hanson. Members, any additional questions or comments? Not seeing any. All those in favor?
Aye.
Anyone opposed? And the motion passes unanimously. I will go ahead and assign this floor statement to Assembly Member Brown May. Last for our work session today is Assembly Bill 218.
Thank you, Chair Miller. Assembly Bill 218 requires the court administrator and each court in this state to establish a program to send certain communications regarding court proceedings by text message. This bill is sponsored by Assembly Member Gonzalez, and it was heard February 19, 2025. There is an amendment which replaces the original bill with new provisions requesting the Nevada Supreme Court to conduct a comprehensive study on court notification processes, including best practices and technological needs. It also asks the court to develop rules or measures to improve trial court notifications and reduce failures to appear or pay. And that's all the amendments.
Okay. Thank you. Members, any additional questions or comments? I trust that all the members had an opportunity to speak with the bill sponsor. Assembly Member Gonzalez? Yes. Okay. Then with that, I will take a motion to amend and to pass Assembly Bill 218.
So moved.
I have a motion from Vice Chair Marzola. Is there a second? Is there a second? I'll take a second from Assembly Member Dahlia. Any additional questions or comments? Not seeing any. All those in favor, please say aye. Aye. Anyone opposed? And the motion passes unanimously. I will go ahead and assign that floor statement to Assembly Member Gonzalez. Thank you, members, for your work with the introductions and the work session. With that, the final thing on our agenda today is public comment. So again, just to remind folks that public comment is not to, again, provide comment on bills that we heard today, but anything else that is under the purview of this committee. We ask that you keep your comments to 2 minutes each, and of course, you state your name and spell it so we have it correct for the record. We will start here in Carson City. Anyone wishing to approach and make public comment? Not seeing anyone. Is there anyone there in Las Vegas that would like to make public comment? Also not seeing anyone. Broadcasting, please open the lines.
If you would like to provide public comment, please press *9 now to take your place in the queue. Again, if you would like to provide public comment, please press *9 now. Chair, there are no callers choosing to provide public comment at this time.
Thank you so much. Well, with that, then we have concluded all the business before us on our agenda today. I am going to recess today because, as you know, today is a deadline day at midnight, and we need to make sure that all bill introductions come out. If there's any additional bills that come out, we will introduce them on the floor behind the bar. So with that, I'm going to go ahead and recess. We will adjourn later on the floor. So we're in recess.